Hi, folks. Good morning and God bless you. May the Lord keep you safe in His tender mercies. I am doing a video today. I'm under a little bit of a time crunch because I got to go into work. But over the weekend, I had a chance to work on an appeal for somebody who's filed a religious exemption. Okay, and my research into this religious exemption is the news is actually quite heartening, and I want to share this with you. First and foremost, let me say, however, that the big picture is this: no employer, no amount of money, no nothing is going to make you safe in the days to come. The only thing that will make you safe is the Lord Jesus Christ and putting your trust and your faith in Him. So if you have a problem with an employer and they don't acknowledge and accommodate your religious exemption, you have to move on from that employer rather than putting poison into your body. And I'm also going to leave a link in this video into something very disturbing footage that I saw last night of a baby born when the mother had taken this poison, and what's happened, the changes that came out. The changes are real, folks. You really have to watch this video. So in any event, employers are covered under the Title VII of the Civil Rights Act of 1964, and that prevents discrimination based on selected categories, similar to asylum, but this category is like an asylum in intra-United States. Asylum seekers come into the U.S. seeking protections on the basis of race, religion, and other kinds of discrimination. Title VII is like our infra-asylum, and you have religious exemptions. And something very important I want to mention: if you're in a state where they've, quote unquote, taken away religious exemptions, bull. They can't do it. It's federal law. No employer may violate federal law. No state may violate federal law. So all these exemptions that they've worked away in California, New York, for example, I think they could be found patently illegal. But listen, I want to share this, the what I did with this brief. Okay, the fact pattern of this brief that I made up is I'm doing this for someone that I want to work with. But listen, this employee rather, has gotten notice from a hospital, say for example, Kaiser, which is one of the biggest employers in the United States. Oh, and I've seen their letters in response to religious exemptions, and they could be considered, they're totally ridiculous. You don't give a provisional exemption, first of all, and you don't have a right to make anything but a limited inquiry into the person's belief. And also, I want to say this is also not, the religious exemption is not only based for Christians, but it can be used by anybody, even an atheist that has a personal and strongly held, sincere, bona fide belief that to do or not do something is against that belief. Okay, so let's dig into this. Well, like I said, I gotta take off for work, but the background to this complaint is that this woman worked at a hospital and was notified that she was required to get the, you know what? Now, in this fact pattern, the supervisor made some comments like she ought to rethink that decision. The worker had some documentation of other employees uh, making fun of her and making her uncomfortable in the workplace, which she, for a very good thing, she documented that by a written correspondence and notified her supervisor. Despite that, the supervisor did nothing to stop that behavior. Okay, so in any event, this person in this appeal filed for a religious exemption, got one of the baloney and patently, bordering on harassment letters back from Kaiser. And so in any event, she has been denied her religious exemption, and she's doing this on appeal. Now, keep in mind, folks, everyone who's in the legal field knows the trial court, you can do some steps before you even get to trial court, right? Filing your religious appeal with your employer. Then in California, it's the FEHA, the Fair Housing, Fair Labor and Housing Employment. Any event, there's going to be a different civil rights commission in every state, and you can ultimately file on your employer with the EEOC. Okay, so listen, folks, I want to give you this information so you can become armed. You don't have, there is no rule that trumps this Title VII or Title IV for students. And I don't have time to get into the students one this morning because I haven't drafted that one yet. But the students are getting screwed over. I've looked at a few of these, such as Cal State Fullerton. There's there's several things totally illegal about Cal State Fullerton's uh, supposed request for an exemption. Just absolutely, they need to be taken into court. They need to be taken into court and held up on a. Anyway, listen to this. I want to tell you. Listen, I'll just get right to the heart of what. This is what employers are required to accommodate. Okay. Under Title VII, employers are required to accommodate the religious practices of their employees unless a requested accommodation is shown to impose an undue hardship. A reasonable religious accommodation is an adjustment to the work environment that will allow the employee to comply with his or her religious beliefs. The need for religious accommodation most frequently arises where an individual's religious beliefs, observances, or practices conflicts with a specific task or requirement of the job. The employer's duty to accommodate will usually entail making a special exception to, from, or adjustment to the particular requirement so the employee is able to practice his or her religion. When an employee's religious beliefs or practices conflict with a particular task, appropriate accommodation may include reviewing the employee of the relieving the employee of the task or transferring the employee or working at home even, for example. So they go on to describe a lot of different ways you can accommodate, but they are required to accommodate this. So for example, if you've been working at a place which unpoisoned people are working, and now all of a sudden they require this of you, you have many options that they are required to do. They are required, you don't apply for a religious exemption, you already have it. It's in law. They are required to accommodate that unless it causes undue hardship. And the criteria for undue hardship is actually quite high. I mean, short of building you a separate building and a separate work area, they have to accommodate it. Now, many folks can we can get into the nitty gritty of this later, but let me just continue on. Agencies. This is based on Kaiser's or hospital's statement that, okay, this applicant, this employee used a form letter that they found off the internet. Well, who cares? Who cares? As long as it contains their substance, their belief, an accurate statement of what they believe. Who cares if they got help for it? Whoa, that's irrelevant. Okay, agency statements that she used a form letter is irrelevant to the fact that complainant expresses her sincerely held religious beliefs. Complainant received assisting in drafting letter, however, the contents of said letter were her own. The substance expresses her firmly and held sincerely religious beliefs. Complainant quotes the Christian New King's Bible in her request. Should complainant be reprimanded for using the words of Jesus Christ? Should courts be prevented from quoting sources, case law, and legislative history when drafting their documents? Surely not. I dare any practitioner when they're drafting something not to use copy and paste 100 times. You copy and paste your case law. You have complaints that are different kind of complaints where all the elements are already laid out. You don't go back to the wheel every time. And neither should anybody who's applying for a religious exemption. Okay, complainant has not been provided with an interactive process. After you file for your religious exemption, and employers are required to engage in what's called an interactive process. Here's where they'll try to trip you up. The key is to ask for an interactive process that's in writing. And you could tell them darn straight, because I need it to protect my record, protect the record, protect the record I'm documenting and maintaining throughout this process. So after you file for a religious exemption, they want to have a meeting, right? Fine. But I want all the questions in writing ahead of time, and I will only be answering those questions. Or I could go to the meeting, I won't say anything, but I will write down all of your questions. Because what they're going to try to do, folks, is get you into a corner where you're talking about all kinds of other things besides your religious exemptions. For example, the medical issues behind it. Imagine the hospital or employer being concerned that you're concerned about medicine. Anyway, about medical issues, right? The irony of it while they're trying to shove this crap into us. So, uh, but they will try to get you into an argument, and then they'll cite your own words against you and say, see, they don't have a bona fide medical request. They're talking about medical misinformation, blah, blah, blah. No, you put them on notice that everything is going to be documented. Okay? Now listen, to show undue hardship, an employer must demonstrate that an accommodation would require more than a de minimis cost. Relevant factors may include the type of workplace, the nature of the employee's duties, the identifiable cost of the accommodation in relation to the size and operating cost of the employer. Ooh, and the number of employees who will in fact need a particular accommodation. The employer needs to demonstrate how much cost or disruption a proposed accommodation would involve. Okay, a refusal to accommodate is justified only when an employer can demonstrate that an undue hardship would in fact result from each available alternative method of accommodation. Okay? And I said, in the instant matter, there is no hardship to the agency, let alone undue hardship. As documented, complainant worked with telemedicine for months. To continue to do so is a reasonable option that was never explored by the agency. That's the employer. Any number of other employees is irrelevant to the instant matter and was never an issue raised by the agency. There is no cost disruption. Hostile work environment. Okay. If they refuse and start giving you a hard time, then you have a claim under hostile work environment. The Supreme Court of the U.S. held that a complainant alleging hostile work environment part is allowed to bring this claim as part of the same part and parcel of the religious exemption um, uh, claim. Okay, so I gotta run, but I want to share more about all of the and then you can get this employer on a couple other torts when they go about their activities, denying denying your religious claim. Also, in this claim, you're entitled to attorney's fees. So if you have to hire an attorney, you're entitled to get those costs back. And plus, believe me, they'll have their time documented and their fees documented well. In addition, this behavior of putting you through hell about getting a religious exemption, and can start to become other torts, other civil torts. Such behavior constituted a pattern rather than isolated incident. Said behavior also constituted civil torts, including but not limited to slander, libel, false light, intentional infliction of emotional distress, negligent infliction of emotional distress. Said behavior constituted a pattern of religious persecution. Said behavior contributed to both physical and emotional injuries incurred by the complainant. In this appeal, I put in that this employee began to suffer stomach aches at work, and then she had to seek emotional and legal counsel. So she had damages, and folks who are going to lose their job certainly have damages. And we need to talk about damages because it's a worthy issue to talk about when you think about it. If you lose your job, and then not only that, but you lose maybe a house, your kids have to have emotional and physical consequences. All kinds of big damages associating to being in violation of the Civil Rights Act, Title VII, and Title IV for students. Okay, I love you guys. Just please let this sink in how easy it is. Not how easy your religious exemption is to access. You already have that right built in. No law, no mandate, no other baloney coming out of these illegitimate folks' mouths can usurp that presently. This law still stands. So, love you guys. Talk to you soon. God bless.